what is your topic on arbitration, right? Arbitration. Right? So first, what we have to understand is what are these arbitration, conciliation and all. So these are called alternate dispute redressal mechanism. Okay, or what we can call as ADR, alternate dispute redressal mechanism, right? So in this ADR or alternate dispute redressal mechanism, so we have arbitration, mediation, and conciliation. Conciliation. CONCILIA, right? Is it okay? Arbitration, mediation, and conciliation. So advantages are definitely there. So we'll talk about
these
that.
Are types of ADR or these are parts of ADR?
These are types of alternate dispute redressal mechanisms.
Okay.
So choosing this means you don't have to go to the legal recourse. So legal recourse is expensive. It is delayed, right? That is, it is time consuming, right? Plus, there is a question of loss of reputation. So instead of going for the legal recourse, right? So we can choose to go for these kind of options, right? So in this, let's arbitration anyway will take up. Let's talk about mediation. So what is mediation? That parties in a dispute, okay, may refer their dispute to an independent third party who will act as the go-between, means try to find a common solution, right? So in other words, the purpose is to find a common solution acceptable to both parties. Is it okay? What is mediation? Yes, please. And mediation is not mandatory, right? Mediation is an initiative by both parties to find an amicable solution. Okay with that? Yes or no?
Yes, sir.
Yeah. So next is your what we call the conciliation. So in case of conciliation, so there is a conciliation commission which is set up to give a recommendation to the parties in dispute. So there is a conciliation commission, there will be conciliators chosen by the parties, right? So they will come up with a recommendation depending on whatever the facts which are placed in front of them. Again, it is a recommendation, right? So it may be acceptable to both parties, it may be acceptable to one party, it may not be acceptable to another party. So unless both parties agree to accept the recommendation, the conciliation cannot succeed. Is it okay what I'm trying to say?
Sir, like like we have for conciliation and arbitration, we don't have any body for mediation.
For mediation, we don't have a body because mediation, you are directly choosing a third party, right?
So is it required to have mediation mentioned in the charter party contract? Then only it can be applicable, or it can be applied later?
Mediation you can try always, right? So mediation is an option which can always be tried. Whenever there is a dispute, in case of a, say, you said charter party contract, there is a broker involved, isn't it? Who has made help you, get the charter party agreement in place. So the broker can act as the mediator and try to resolve the dispute between the parties. Still, it doesn't work out, then the question of going for arbitration, right? Okay.
Whatever the outcome, both the parties.
Whether it is mediation, mediation is trying to get a compromise between the two parties. So if mediation doesn't work, it is quite obvious that the mediation has failed. Conciliation, then it is coming as a recommendation, so not binding on the parties.
Sir, I can put it like that. Just say two parties are involved, then the court will do mediation, or like you bring your lawyer. And conciliation is like your parents telling you,
No.
listen to us if you want to.
Proceedings is separate.
No, sir. In a normal way, I'm talking.
Judicial system, right? Okay. So court can tell you that try for mediation. Court can tell you that try for conciliation. Court can tell you that your agreement says arbitration, so first go for arbitration, right? But when the court proceeding is there, it is a judicial proceeding, so it will take its own time. And there are so many pending cases before the court, right? After one hearing, the next hearing may be coming after months. So it can go on. And plus the expenses which you will incur. And plus the proceedings are in open court, so everybody will come to know whatever is going on. So your rivals can take advantage of the details which are being produced in the court. Is it okay?
Yes, sir. Go ahead, sir.
Yeah. So next is your arbitration, right? So which we are going to go for, right? So this is the third one and the most important one, because arbitration, whatever the outcome of the arbitral tribunal, so that will be final and bounded, right? So is a form of ADR, that is alternate dispute redressal. So what we can say is advantages of ADR. Why to go for ADR, right? Lower costs, okay, greater flexibility of process, higher
Time saving.
confidentiality, okay, greater likelihood of settlement, this is in general, right, for any type of ADR, right? Choice of forum, so you can choose which law, which country, right? You can choose the arbitrators, you can choose the conciliators, right? Choice of solutions, say in case of your mediation or conciliation. So you have a choice to accept it, not to accept. Obviously, when you're going for arbitration and then a decision is given, then it is binding on you, right? So this is the arbitration is out of this three which we discussed. Arbitration is one of the most popular forms of ADR. Is it okay? Yes, please.
For the first point, the lower cost is for all the three, right? Not just arbitration.
Lower cost, yes, definitely, right? Just think of the legal cost which would have been involved because it would go on for years together, right? And think of the charges which are required by the lawyers, right? Okay.
Sir, this arbitration also facilitate a faster resolution of the dispute, isn't it?
Yeah. So that is what we are talking about. That it will be a quick solution, right? So within
Yes, sir.
1 year, within 6 months, maximum within 18 months, right? Okay.
Okay, sir. Okay.
That is the time frame we are looking at. Okay. So next, write the key elements of arbitration agreement. Okay, key elements of arbitration agreement. So first is the consent. Okay, so an arbitration cannot put on here. An arbitration cannot happen without the consent of the parties involved in dispute, right? Okay, so the agreement itself clearly specifies the desire of the parties to arbitrate their dispute. Okay, so in the agreement, say supposing if I take charter party agreement, so there will be an arbitration clause which is saying that in case of a dispute, we will try to resolve the dispute by arbitration, right? Okay, so if this is the case, then you cannot go for legal proceedings straight away. You must go for arbitration. And then if you have gone for arbitration, as I said, arbitration, whatever the outcome of the arbitral tribunal is final and bounding, and the possibility of appeal will be very limited, right? Appeal and going to the court. So that possibility will be only in very limited cases. Is it okay?
Yes, sir. Sir, in oral, they asked this question that in arbitration, is the award binding?
Yeah.
So we have to say yes.
We will say that the award is final and binding, and then we will also have to give the section number from the Indian Conciliation Act, right? That where there is the possibility of appeal. So as we go along, so we'll have all those answers, right?
Okay, sir.
Okay. Next
Rajesh, sir.
Presiding authority. Yes, please.
Sir, the incident which took place in India when two fishermen were killed, so the final decision was through arbitration only, correct, sir?
But that was that was through the Permanent Court of Arbitration. That was a body under, as per the authority in UNCLOS, right? So went for Permanent Court of Arbitration. We are talking about arbitration in India, right? Whether it is a domestic arbitration, whether it is a foreign arbitration, right? Or if an arbitration has taken place outside the country in some foreign country, but that award has to be executed in India. So that is our scope. We are not talking about an international body going for arbitration, like the Permanent Court of Arbitration, right? Okay.
Okay, sir. Thank you, sir.
So presiding authority, right? So this authority is known as the arbitral tribunal. Don't think that it is tribunal, so there will be always three, right? So there can be even 5 arbitrators in a tribunal, right? it is similar to a judge that presides over a court of law. Okay, so you can think it that similar to this, right? So the arbitrator is also under oath to take to perform his duties, like just like a judge, and he's supposed to act in an impartial manner. Is it okay? Second, point B. Yes, please.
Yes, sir.
Yes,
Yes,
sir.
sir.
Okay. Next is your seat of arbitration. Okay. So what is the seat of arbitration? The seat of arbitration determines the courts which would exercise jurisdiction over the arbitral proceedings. Okay. So which court has the authority to send you for arbitration? Which court has the authority to accept an appeal against an order of the arbitral tribunal? So that court has to be defined. So whether it is a district court, whether it is a high court, whether it is the Supreme Court. Okay. So what is the seat of arbitration?
So that will be written in the contract.
No, that will be written in the Act of India, right? Okay, that which court?
The Act of
Indian Act, right?
Indian Act. Okay.
Right. So we'll have the Arbitration and Conciliation Act of India, 1996. Okay.
But even though there are no legal proceedings involved, we have to go through court for arbitration.
If there are no legal, see, if it is written in your contract that the arbitration clause is there, then you can directly go for arbitration, right? And you are supposed to go for arbitration. Even one party can initiate the arbitral proceedings. But supposing arbitration is not mentioned, okay, and then you have gone to court, the court can suggest you to go for arbitration, and if both parties agree, then you go for arbitration.
Okay.
Right? But that time the arbitration is not binding if it is not part of the contract.
Okay.
Okay. Next is your party autonomy and procedure. So in this arbitration, again you have to write in the clause itself, right? Gives the parties the choice to select gives the choice to select applicable laws. Okay, so in the contract only you agree that which country, which law, right? So you choose, especially.
Sir, applicable what you have written?
Laws. Okay, especially if the arbitration is an international commercial arbitration. So two countries are involved, right? So two countries maybe companies are involved in dispute, but they have chosen that the arbitration will be carried out as per law of the third country. Even that can happen. Is it okay?
Okay.
The last one is the finality of right, of outcome. Okay. So in general, no appeal lies against an arbitral award. We'll see exceptions also, right? But in general, right? However, an arbitral award can be set aside by court in certain exceptional cases. Okay. Example, fraud. Is it okay?
Yes, sir.
So, just make a small flow chart, right?
तो थोड़ा नीचे कर दीजिए सर, ऊपर का लिखा नहीं था. An arbitral award can be. Okay, sir.
Okay. Type of arbitration clause. We can have basis that international commercial arbitration. Okay. And we can have also what is called domestic arbitration. Okay. So in this international commercial arbitration, who is going to exercise the authority? The High Court. Okay. And domestic arbitration, both the district court and High Court. Is it okay?
This is in general or for India?
This is for India, right? Okay. As per the Indian Arbitration and Conciliation Act, this is how it will be. For international commercial arbitration, the authority is the High Court. For domestic arbitration, can approach the district court or the High Court, right?
Sir, one question, please.
Yeah.
Sir, the judgment of the court can be appealed in the higher court?
Can be appealed in the Supreme Court, yes, if the court has given a judgment. But the first thing is whether the High Court or the District Court will entertain your appeal against the order of the tribunal or not, right? So that will be only in certain exceptional cases. Okay.
Thank you, sir.
Yeah. So in the Arbitration and Conciliation Act only, we will see that the provision for appeal against a court order. Okay. Next, what we are going for is what is called the Indian Council of Arbitration. Okay. Or the ICA, Indian Council of Arbitration. So this is your premier arbitral institution in India, right? Registered under the Societies Registration Act of India 1860, right? Not for profit basis it operates, right? Head office is in New Delhi and has 10 branches across India. Okay, so far?
Yes, sir.
Okay.
Yes, sir.
One of the most important arbitration centers in Asia Pacific. Okay. And India wants to become a hub for international arbitration dispute redressal. Okay. So that is the intention. So this ICA was established in 1965, right, as a specialized arbitral body at the national level under the initiatives of Government of India, okay, and apex business organizations like FICCI. What is FICCI? What is the full form? Federation of Indian Chambers of Commerce and Industry. Okay. Federation of Indian Chambers of Commerce and Industry. Done with that?
अंदर क्या लिखे हैं सर?
Federation of Indian Chambers.
ICA established in 1965 under the
initiation of Government of India. Under the initiation of the Government of India and apex business organizations such as FICCI. Okay.
Okay, sir.
So now, which country is dominating in this arbitration? London?
France. Right?
Sir, the full form of FICCI.
FICCI, as we said, Federation of Indian Chambers. Federation of Indian Chambers of Commerce and Industry. Okay. So this is a trade association. Okay. ICA is now an autonomous body. That means it is independent. No more government direct interference, but some kind of control is still there, right? But this is an autonomous body, independent body which is there, right? And the purpose is your quick settlement of disputes. Is it okay?
Yes, sir.
Everybody fine with this? Can we go on?
Yes, sir.
Yes, sir.
Yeah?
Yes, sir.
Okay, good. So now we will go by the PDF text, right? So just write this. So this is your maritime arbitration rules of given by ICA, Indian Council of Arbitration. The Maritime Arbitration Rules of ICA. Okay with the reference?
Yes, sir.
So in this, we'll not go into everything. So we'll just go from the oral point of view. So just write who is the registrar. So registrar means the registrar of the ICA. Okay. Registrar means the registrar of the ICA. Okay, so everywhere this word registrar will come. So registrar is the registrar of the parent body, that is the ICA. We will also set up a maritime arbitration committee. So just write maritime arbitration committee. So this ICA will constitute a maritime arbitration committee. And who will be the nominees? You can see here, right? So just write this. The council shall constitute a maritime arbitration committee, and such committee shall consist of nominees of the following. So nominated members. So 2 by the ICA, 2 by the Ministry of Shipping, 1 by the Ministry of Law and Justice. So you can see government, some kind of interference is still there, right? Then you have the Indian National Owners Association, SCI, representatives of the P&I correspondents, and representative of steamer agents. Yeah. Okay. And now come to the function of the Maritime Arbitration Committee. So what it will do, the function of the MAC. Empanelment of arbitrators. That means it will maintain a list, right? It will keep a number of arbitrators on its panel. And the parties will have to choose the arbitrators from this panel itself. Okay. Empanelment of arbitrators, probably one of the most important function of the Maritime Arbitration Committee. Provision of guidance to the arbitrators and parties in general conduct of arbitration. So they issue the code of conduct for arbitration. Your duties of the arbitrator, duties of the parties, and all that, right? Determination of the scales of arbitrators' fees. So how much remuneration, right? What will be the arbitrator's fee, registration fee, administrative charges from time to time. So they do revise it. Publication of arbitration awards, only when necessary. If some party has an objection, then the details of the proceedings will not be made public. Any doubt regarding the rules, the clarification will come from this committee. Appointment of arbitrator, presiding arbitrator when required. In general, the parties are supposed to choose the arbitrators, and the arbitrators among themselves should choose the third arbitrator as the presiding arbitrator. But in case there is a failure or there is lack of consent between the two parties on a common presiding of arbitrator, so then this committee can step in. review of the progress of arbitration cases. Yes, please.
Is there any tenure for the making of this committee, the members of this committee? Is there any tenure?
Tenure means we'll see that there is an age limit, right? So after which they will retire, right? In any case, they have to be at of age, means not less than 18. Okay.
It's not like that in every 5 years the committee has to be re-elected or like this. Anything.
Not like that, right? So up to their retirement age, they can continue to be on the panel. Anyway, the panel can always be revised by the arbitration committee, right? Okay. Done with this, point 127.
Yes, sir.
Next, we come to the panel of arbitrators, right? So who can make it to the panel and up to what age, right? The committee shall maintain a panel of arbitrators who have experience and reputation in shipping and maritime practice. So just write this, in shipping and, so this is the qualification if you are going for maritime arbitration, right? In general, no such specific qualification is required. The only thing is that the person should be of age that is above 18 years, right? And he should be of a sound mind, right? Apart from that, no specific qualification that 10 years as practicing lawyer or this, that, nothing like that. Okay. But if you're going for maritime dispute arbitration, then obviously you should have experience and reputation in shipping and maritime practice, knowledge in maritime and shipping laws, right? And one more important part, you see, persons of integrity. Okay. So definitely above 18 years, right? So of age, person of integrity, reputation, right? And these are some of the special, expertise which you require in the marine field to make it to the panel of maritime arbitrators. And there is an age limit, right? So a person who has attained the age of more than 80 years will automatically cease to be the member of the panel of arbitrators.
So basically, this is the requirement for the committee, right? Panel of arbitrators who are in the committee.
In the panel of arbitrators
committee.
In the
maritime arbitration committee, उन्हीं का है ना ये मतलब requirements.
नहीं, कमिटी ने एक panel of arbitrators बनाया. Committee, the constitution of the committee, like who are the members of the committee that he wrote, no?
अच्छा ठीक है.
Nominees from here, there, all that. Now the committee is maintaining a panel of arbitrators. So when it is choosing the arbitrators, this is the qualification to look for. Okay.
This is not the qualification of the committee members. वो अलग से panel है, उनके लिए है ये qualification.
Panel of arbitrators. Yeah, arbitrators का qualification.
Okay.
Not of the committee members. Committee members तो सीधा nomination से walk through, right? Okay.
Okay. सर जैसे मिनिस्ट्री ऑफ शिपिंग से 2 बंदे इधर रहेंगे तो वो 2 बंदे कौन सिलेक्ट करेगा ये?
मिनिस्ट्री ऑफ शिपिंग से आएगा, right?
Okay.
Nothing like that.
They will decide who to send.
They will decide. So obviously it is like a, government wants to keep some kind of a hold on this, right?
Okay.
So that is again one of the, demerits of this, that supposing there is a dispute with the government of India, then which side this will be tilted, right? Will be towards the government, isn't it?
Correct.
So you cannot expect a fair judgment in those cases.
Okay. Sir, so these nominees which are coming through the ministries, they would be normally the bureaucrats, right?
Normally the bureaucrats. Right?
Okay.
Okay, done with this. Can we go on?
Yes, sir.
Yeah, good. Next is the scope of application, that where you can go for arbitration, right? In which kind of maritime disputes there is scope for arbitration. So please write down these these rules apply to maritime disputes in the following, in respect of the following: interpretation of charter party or any contract of affreightment, bill of lading, carriage of goods by sea, marine salvage, towage of vessels or other floating objects. So you can see it is extensive, right? So it will cover the whole scope of any kind of maritime dispute. So as long as you have an agreement for arbitration, you can go for arbitration. And if there is no standing agreement, then the question of whether the two parties want to try arbitration.
सर एमएस एक्ट में आर्बिट्रेशन के बारे में कहीं पे जिक्र किया है?
क्या चीज? come again?
Has arbitration been used in MS Act, means in any section?
This is the arbitration, not part of MS Act. There is a separate Act of India, Arbitration and Conciliation Act of India. Okay. So you can see Arbitration and Conciliation Act of India 1996 as amended. Okay. Latest amendment 2021 amendment.
सर जैसे 4th point damages arising due to collision, अभी इस केस में arbitration act will take precedence or admiralty act will take precedence?
Admiralty Act is a separate part altogether, right? Admiralty Act is going for the legal course, isn't it?
Oh yes.
So you are getting an order of the court and getting the something held up to settle your dispute. So similarly for the salver, if the salver has not been paid, so he can get an order of the court and hold on to the salvage property, right?
Yes, sir.
That is a different setup. Here is when there is a dispute regarding certain aspects. So they want to settle it here by arbitration, because the contract said that the salvage contract said that in case of any dispute regarding the remuneration, it has to be settled by arbitration.
Okay. Okay.
Sir, even if not expressly mentioned in the contract, in that case, if the salver and the ship owner both agree to go for arbitration with respect to the remuneration, it's okay, right? It's possible, right?
Even the courts will encourage ADR.
Yes, yes, for arbitration.
Ask that would you like to try mediation, conciliation, arbitration, right? Because they also want to reduce their caseload, isn't it?
Okay, sir. Okay, thank you.
But in case of salvage, if the salvers have not been paid as per their expectation, then they can go for the Admiralty Act.
They have not been paid as per the expectation. Now that is a different word altogether, right? The question is that how the remuneration was to be fixed. Right. If the remuneration was to be fixed by arbitration, then we have to go as per arbitration. What was there in Article 13? What it said? That for the property salvage, and in the LOF form, was there any defined amount for the property salvage?
No.
No, sir, no.
Open form. And how the remuneration will be decided?
By arbitration, sir.
By arbitration.
Okay.
Then go for arbitration, right? Okay.
Okay.
The ship owner is not saying that I will not pay, so you exercise the Admiralty Act. Ship owner is saying that our contract says we decide by arbitration, so we go for arbitration, right?
Okay. Okay.
Okay. Next is the interpretation of any shipping documents, disputes regarding to ownership of vessels, aspects related to lines and mortgages, GA, particular average, or any matter regarding marine insurance, wreck removal. So just write the whole thing. So what we can see is that it is covering almost any maritime dispute. So can be resolved through arbitration. So almost full scope.
Sir, except in case of criminal proceedings, right? As far as there is no criminal proceeding involved, all civil matters can be sorted out through arbitration.
For monetary compensation, if there is any criminal proceeding, do it separately, right?
Yeah, okay, sir.
This is only for the monetary compensation, that's all, right? Or any property, who can take possession of it, right?
So that fourth point for that dispute with in collision port.
Come again?
That collision in port. The fourth point. So the fourth point is another legal proceedings where collision in port, grounding, and all that.
Okay.
So that damage arising out of collision, grounding, whether in port or at sea, including damage to fixed or floating objects at port. So this contract, like we told that in contract, it is mentioned that any problem arises and we'll have to first go for arbitration. So what kind of contract with the port? I mean, that I understand, sir.
No. If there is an existing contract, then it has to be by arbitration. If the port laws, you are visiting the port of a particular country, isn't it? So it is governed by its own national laws. And if the law of the port is saying that any dispute happening in port has to be settled by arbitration, and if you agree to call to that port, you have agreed to the clause.
Okay. All right. Okay.
So please scroll down, sir.
Who is paying for the fees of arbitration for the owner? P&I?
We'll come to that, right? But right now, just think that both the parties must pay equally. Okay. Done with that? Can we go on?
Yes, sir.
Yeah. Next is the commencement of arbitration. So any of the parties which has agreed into an agreement for resolving the dispute by arbitration under these rules may make a written request for arbitration to the registrar of the IC. So any one of the parties can move the IC. You don't need the consent of the other parties as long as there is an existing clause in the agreement. Okay.
Yes, sir.
Okay, done with this, right? So let's move on. Now we come to the appointment of arbitrators. So how arbitrators are appointed or nominated, and how the arbitrators can be removed, right? So just write this: nomination, appointment, and removal of arbitrators. Okay. The number of arbitrators, it should always be odd number, right? So either you will have 3 arbitrators or you will have 5 arbitrators. Then only you can come to a decision. If it is even number, then it will be split up, maybe 2 in favor, 2 against. Then you cannot come to a decision. It has to be odd number of arbitrators. So the number of arbitrators to hear the dispute shall be determined as under. Okay. First one, where the claim does not exceed 1 crore and the arbitration agreement does not specify otherwise, sole arbitrator. Reference shall be deemed to be a to be with a sole arbitrator, means single arbitrator. Where the claim exceeds 1 crore and the arbitration agreement does not specify otherwise, the dispute will be heard by 3 arbitrators. Is it okay? So single arbitrator if less than 1 crore, and if more than 1 crore, 3 arbitrators in the tribunal. Fine with that? Can we go on? Yes, please.
Yes, sir.
Yeah. The number of arbitrators to hear the dispute under the rules shall be either 1 or 3, and to be appointed from amongst the ICA Maritime Panel of Arbitrators. So that 1 arbitrator or 3 arbitrators all have to come from that panel itself. Okay, so how to choose that single arbitrator, that is the sole arbitrator, and how to choose those 3 arbitrators. In case a sole arbitrator has to be appointed, the registrar, by a notice in writing, will call upon the parties in the dispute to forward the name of an agreed arbitrator. So the 2 parties have to agree to a common arbitrator in case of a sole one. And then there will be a time frame, say here not more than 30 days. So just write the line, last line, right? If the parties fail to agree on the person to be appointed as sole arbitrator within the time granted by the registrar, then who will appoint the sole arbitrator? The registrar, in consultation with the chairman of the committee, shall appoint the sole arbitrator, again from the panel. So either the 2 parties consent to the same name to be chosen as the sole arbitrator within 30 days, right? Otherwise, the registrar, in consultation with the chairman of the committee, will appoint the sole arbitrator from the panel.
Okay, sir.
Yeah?
Yes, yes.
Good. Where the reference is made to 3 arbitrators, registrar shall in the first instance call upon the parties to nominate 1 arbitrator each. So each one will choose 1 from the panel. That means the 2 parties together will choose 2 arbitrators, and there will be a time frame for that. Is it okay?
Sir, how would remaining 1 will be appointed by
No, no.
arbitration
दोनों
committee?
मिल करके the two arbitrators together will choose the third one, right? Okay.
All right.
So first the two parties had to choose one each. There is a time frame, and if a party to the dispute refuses or neglects to appoint an arbitrator within the time frame, then who will nominate? The registrar will nominate an arbitrator on behalf of that party. So registrar is stepping in at every step, at every place where a party is failing to do its responsibility.
In the first case, all the parties they have to agree for a sole arbitrator.
Yeah, because there was a single one, and if there is no agreement on the sole arbitrator, then the registrar is right.
Okay.
Here, each one is given one choice, and if they don't exercise that choice within the time frame, again the registrar is doing it on behalf of the parties, right?
Okay.
The two arbitrators, as appointed aforesaid, shall appoint within a time frame the third arbitrator. So the two will appoint a third choose the third arbitrator, who will be the presiding arbitrator. So two were chosen by each of the parties, and the two together will consent to the third one. Again, there is a time frame, and if the two arbitrators don't agree on the third one, then who will appoint? The registrar, right? Again, in consultation with the chairman, will appoint the third one to be the presiding arbitrator. So there is a particular time frame after you have moved the application by which the tribunal will be set up in any case, right? So you cannot delay it too far. So there are time frames given. So everything is time bound in case of arbitration, right? Okay.
Yes, sir.
Yeah. Now about the challenging the arbitrator, right? Seeking removal of the arbitrator. So just write this: any party shall have the right to challenge the appointment of an arbitrator. Any party shall have the right to challenge the appointment of an arbitrator on receipt of his notice of his appointment. On what grounds? For reasons which disqualify him as impartial or independent arbitrator. If there is a conflict of interest, and if you have come to know, so one party comes to know that this arbitrator was a practicing lawyer or something of the other party sometime back in the past, so there is a conflict of interest. So that means this arbitrator will not do an impartial judgment. So then you can seek the removal of the arbitrator. Okay. The challenge of an arbitrator shall be made within 15 days after his appointment has been communicated to the challenging party. Or within 15 days after becoming aware of the reason for which the challenge is being made. So supposing the registrar decides to accept this and remove the particular arbitrator. So now you have a missing arbitrator. So then now the party whose arbitrator has been removed, so the party will be given the option to choose another arbitrator to fill up the place.
Can this be challenged while during an arbitration process also?
During an arbitration process, so there is a time frame what we are seeing, right? So during an arbitration process, not a problem, right? So the committee can remove at any time. You can also challenge. What it says is, or within 15 days after his becoming aware of the reasons for which the challenge is made. So you become aware of the reason at a later stage, and then you make the challenge. So whenever you got the information from there, 15 days, or when you were informed that a particular arbitrator has been appointed, and if you had prior information, then from there 15 days, right, to challenge. Okay. And decision of the registrar or any member of the arbitration committee. Shall we go on?
Yes.
Next is removal of arbitrator. Now this is what we are talking about, the authority of the committee itself can remove. The committee may at its discretion direct the removal of an arbitrator who is unable to function his duties, okay, or if he is not fulfilling his functions in accordance with the arbitration rules and its code of conduct and guidelines. So not following the rules, not following the code of conduct, right? Or is adjudged insolvent, bankrupt, or convicted in an offense involving imprisonment, then he will be removed from the panel. So if an arbitrator is removed, so binding on the arbitrator as well as on the parties, right? So a new arbitrator will come in to fill the place.
Yes, sir.
Okay, done with this so far?
Yes.
Yeah, good. Next is the venue of arbitration. Okay, so please write venue of arbitration. Venue of arbitration under the rules shall be any place in India. So we saw that there are 10 places, right, where this ICA has got its presence. Anyway, the arbitration tribunal can decide on carrying out the proceedings at any particular place, as long as there is agreement of the parties. But where the claimant and respondent are unable to agree to a common venue, they are not in agreement for a common place, the default location will be New Delhi, the head office, right? Okay, shall we continue?
Yes, sir.
Yeah. Next, come to power of the arbitrators, right? What authority the arbitrators have. So they have got certain powers, and they also have got certain immunity, certain defenses, right? So first, let's talk about the power of the arbitrators. Okay, power of the arbitrators shall include, first, to call for all documents within the possession of the claimant and respondent, to examine any witness on oath or affirmation, to call for giving evidence by affidavits, and even when arbitration is going on, the parties are trying for a settlement. So if the settlement works out, then the arbitrators have no problem in accepting the settlement because it is already a solution to the dispute. So if the parties have reached an amicable settlement of dispute, or any part thereof, even part of the dispute is settled by amicable settlement, right? Then the arbitrators will pronounce an award in terms of the amicable settlement. So they will accept that part of the dispute settlement and declare it as an award, right? So they will give the award accordingly. Means it will be given a final legal authority, right? So the order of the arbitral tribunal is like the decree of a court, okay, and is enforceable under the law.
So can you repeat this second point?
Second part, if two parties are in dispute and there is an arbitration proceeding going on, and finally they come to some kind of a settlement, either for the whole dispute or for part of the dispute is settled between them, they have agreed. So that settlement which they have done can be declared as an award by the tribunal, right? So part of the dispute is now over, or maybe complete dispute is over, right? So that is what we are talking about here. Is it okay?
Yes.
Shall we go on?
Yes, sir.
Yes, sir.
Yeah. Next is the indemnity, right? What protection for the arbitrators? The indemnity. Okay. The council, the committee, the chairman, the registrar, and the arbitrators. Okay. So we are interested about the arbitrators part. Arbitrators shall not be liable for any act or omission in whatever capacity they may have acted in connection with or in relation to arbitration under these rules. So you cannot say that the arbitrator missed out a particular point, right, or neglected a particular point. The parties are themselves required to contest the proceedings regarding the validity of the arbitration agreement before the court. And the second part is even more important. No party shall bring or prosecute any suit or proceedings whatsoever against the tribunal or any member thereof. So you cannot file a case against the members themselves. So you can question their judgment, but you cannot question them, the members themselves in court. Is it okay?
Okay, sir.
Yeah. So this was the indemnity part, right? Next, come to what is called fast track arbitration, right? So just write one line to that. What is fast track arbitration? The parties may opt for fast track arbitration and request the arbitral tribunal to decide the reference in a fixed time frame of 3 to 6 months or any other time agreed between the parties. Okay, parties may opt for fast track arbitration. So if they opt for fast track arbitration, then obviously the tribunal also has to work a lot, right? So possible that additional charges may be applicable, right?
सर नॉर्मल केस में कितना टाइम चलता है?
Normal is, ideally 6 months, not more than 12 months. And if the parties agree that we will continue further, then 18 months. And if the court says that no, continue, then it can even go beyond 18 months, right?
Okay.
Okay.
तो उस पे भी तो ज्यादा पैसा चार्ज करेगा सर?
उसमें चार्ज हो सकता है, बट उसमें क्या है ना कि दे आर नॉट इन अ हरी. यहाँ क्या है, फास्ट ट्रैक में अभी जल्दी जल्दी करना पड़ेगा. आप बोल रहे हो 3 महीने के अंदर करना है. दिस इज स्पेशल रिक्वेस्ट, isn't it? Which is coming.
Okay.
So then whatever was the fees of the arbitrator and whatever the administrative charges, now these will shoot up. Right?
Okay.
So done with this, can we go on? Yes, please.
Yes, sir.
Okay, good. So awards, right? So here comes the time frame, what you were asking, right? So just write awards. The tribunal shall make the award as expeditiously as possible.
सर वो 16 थोड़ा स्क्रॉल कीजिएगा.
Okay.
Okay, thank you, sir.
Well, so next you come to awards. The tribunal shall make the award as expeditiously as possible, preferably within 6 months from the date of reference, subject to a maximum limit of 12 months from the date on which the tribunal was set up, right, entered into force. Okay, so this is your normal setup, preferably 6, maximum 12. And if the parties mutually agree, then they can request the registrar to extend it for a further period of 6 months. So then how much it becomes? 18 months.
So the cost of arbitration can be claimed from P&I.
The cost of
arbitration can be claimed from P&I.
Cost of arbitration will be claimed from the parties themselves, right? Okay.
Just later on can be claimed from P&I.
Cost of arbitration, from the P&I club. That depends on what is the type of arbitration which you are having, isn't it? So legal charges may be payable, right, depending on whether the dispute itself was within the scope of P&I or not within the scope of P&I. If any dispute was within the scope of P&I, it is directly payable. If any dispute was not within the scope of P&I, then the legal charges are only payable if included in FD and D, right? Clause. Okay.
Okay.
Right. So let's go for the next one. If the award is not made within the period of 12 months or 18 months, as the case may be, then the mandate of the arbitrator shall terminate. So that means you have to think that arbitration has failed. Unless the court has either prior to or after the expiry of the period further extended the period for passing up. If the court says so, court is the final authority. You know, district court, high court, right? What type of disputes? If the court says that no, continue with the proceedings, continue, right? Otherwise, this is the time limit. So after 12 months or 18 months lapse, as the case may be, your arbitration has effectively failed.
So what is the FT and D you mentioned, sir?
What is the next?
The FT and D. That is like when any issue happens, the dispute is not within.
You're speaking too softly. Can you please speak louder?
Sir, you have told that like when the scope is not within the P&I, then it is charges is as per the FT&D clause. What is the FT&D clause, sir?
FD&D is trade demurrage and defense, right? It is for legal expenses incurred by a party in fighting legal cases for those disputes which do not fall under the P&I club cover.
Okay.
Right?
Okay.
सर P&I में class 1 class 2 करके आता है सर ये class 1 बोलेगा तो ये class 2 FTD करके आता है सर.
Yeah, that is the class 2. FTD is your class 2. P&I covers. Okay.
Thank you.
After the conclusion of hearing of the arguments and submission of documents, so supposing the hearing is closed, right? So you have already heard the arguments and the documents have been submitted, including written arguments. So then he cannot reserve his judgment. Arbitrator cannot reserve his judgment endlessly. So there also there is a time frame. So your hearing is over. The arbitrator shall submit their award to the registrar as early as possible, but not later than 60 days from the date of closing of the hearing. So you see the complete package is time bound, right? You do not have scope for delay anywhere. Okay, let me know once you finish. Yes, please.
Yes, sir.
Now, what happens to the award? Award will be implemented definitely. The council may publish. Council is the ICA, right? May publish or otherwise circulate any award made under this rule in any arbitration journal, magazine, report, etc. Means it can be made public unless notified in writing by either party not to do so within 15 days of the award. So if you want it to be kept private, you must raise your objection to this, not to publish the award.
Yes, sir.
Is it okay, everybody? Yes, please. Okay. Now come to the fees of the arbitrators, right? The arbitrators' fees, the administrative charges, and the stamp duties shall be borne by the parties in equal share. Arbitrators' fees, administrative charges, stamp duties shall be borne by the parties in equal share.
Yes, sir.
Okay. Next, this is your arbitration clause. So we said that there will be an arbitration clause included in the contract. So just write how the wordings of the arbitration clause should be there, right? In your charter party contract, or for that matter, any maritime contract. All disputes arising under this charter party shall be settled in the country India in accordance with the provisions of, then you choose the law, Arbitration and Conciliation Act 1996 as amended, and in force from time to time, and under the maritime arbitration rules of the ICA.
Yes, sir.
Okay. The arbitrators shall be chosen from the maritime panel of arbitrators of the ICA. So you can see this kind of a statement, it is there, say in the charter party contract. Then we are clear. Any dispute settlement only in India, you have to follow the Indian Act, Arbitration and Conciliation Act. And since it is a maritime arbitration, so we have also mentioned that maritime arbitration rules of the ICA to be followed. And also you have to choose the arbitrators from the panel. So everything is well defined.
So next is with regards to the scale of the arbitrator's fees and administrative charges. So first, with respect to your registration fees. So this is as per your, as of with effect from 2022. So these are the charges. So registration fee shall be payable with respect with regard to amount in dispute, and how much will be the registration fee. So you can see 15,000 plus applicable taxes for claims up to 1 crore. So based on the amount in dispute, so if the amount in dispute is up to 1 crore, then the registration fee is 15,000. And if it is more than 1 crore, then the applicable fee will be 30,000 plus taxes. All right. Next one is your arbitrator's fees and administrative charges. So in this, what is the arbitrator's fees? So just try to remember some figures. You don't have to remember all. So up to 5 lakh. So arbitrator fee is 60,000 for each arbitrator. Then from 5 lakhs and up to 20 lakh, it is 60,000. Plus 3.5% of the claim amount above 5 lakh. We'll have to do this calculation to come to the figure. And likewise, we have for others. So no need to remember all this. Only just remember 1 or 2 will do, right? So that is all about the maritime arbitration rules. And this is the latest one of 17th Jan 2022.
Next, what we have to go for is the Arbitration and Conciliation Act 1996 of India. Obviously, in this we are not going to now study everything because we have studied the rules and the rules are as per the act only, right? So most of the sections of the act have already been covered. So here our main focus will be that where there is a scope to challenge the award of a arbitral tribunal. Okay.
Someone's mic is
When an arbitration can be challenged in court. Yeah, please go ahead.
Someone's mic is on.
Someone's mic is on? No, I don't think so. Everything is. Are you getting any disturbance?
बीच में थोड़ा disturbance आ रहा है. अभी ठीक है.
Okay, so we'll see that there is some scope which is there for challenging this award, right? But only in certain cases. So shall we go on? Yes, please. Okay, so just write this. Court means in case of arbitration other than international commercial arbitration. The principal civil court of original jurisdiction in a district. That means the district court, right? And includes the high court also. Okay. And in case of international commercial arbitration, the High Court. So it is the High Court, right? In case of international commercial arbitration. Remember that flow chart which we made? Yes, please.
Yes, sir.
So what do we mean by international commercial arbitration? So when we say international commercial arbitration, we are not saying that the arbitration is being held in some other country. The arbitration proceedings are being carried out in India. But how it is an international commercial arbitration? Okay, so just write this. International commercial arbitration means an arbitration relating to disputes out of legal relationships, whether commercial, whether contractual or not, considered as commercial under the law in force, right? So we are only talking about commercial disputes. Where at least one of the parties is an individual who is a national or a habitat or habitually resident in any country other than India. So you need a foreign player, right, in dispute. So then we will call it an international commercial dispute. So there is an individual who is a foreigner, who is a national or a habitually resident in any other country other than India. There is a body which is incorporated in any other country. So there is a foreign company involved. There is an association or a body of individuals whose central management and control is exercised in any country other than India. So the main functioning office is outside India, or it involves a dispute which involves a foreign country, the government of a foreign country. So then it can qualify for a international commercial arbitration.
Otherwise, it will be domestic arbitration.
Otherwise, if both are Indians, right? or both companies are in India, then it is a domestic arbitration, right?
Okay.
Okay. So at least someone should be of a foreign player, right? So then only we will call it an international commercial arbitration. Otherwise, we will not call it as an international commercial arbitration. Okay. Done with this?